Hello, and welcome to Mackenzie Friend. Today we're going to look at what happens when a parent dies. But first, the usual disclaimer. Whilst I hold a law degree majoring in family law, I choose not to practice nor seek admission, so any information cannot be relied upon. Specific questions should be directed towards an accredited family law specialist. Okay, the issue. What happens if a parent dies and there are no provision in parenting orders for this situation? To look at this, we'll look at 65K. Which states what happens when a parenting order that deals with whom a child lives with and does not make provision in relation to the death of the parent with whom child lives. Now, this section applies if a parenting order is in force that provides that a child is to live with one child's parent and that parent dies, then parenting orders does not provide for what happens on that parent's death. In section 2, the surviving parent cannot require the child to live with him or her. Surviving parent or other person, subject to 65C, may apply for a parenting order that deals with the person or persons with whom the child is to live, and is application under subsection 3 by a person who does not, at the time of application, have any parental responsibility for the child. Any person who, at that time, has any parental responsibility for the child is entitled to be party to the proceedings. So, quickly looking at what 65C is, who may apply for a parenting order. This essentially means standing. So a parenting order can be made by either or both of the child's parents, or the child, or a grandparent of the child, or any other person concerned with the care, welfare, or development of the child. So we'll look at some case law. This is a case in 2013, which was a decision by the full bench of the family court called Newton and Whiteman. Now, in the facts in this matter, upon the death of the mother, under 65K, the maternal grandmother challenges the father and seeks the child reside with her. There were consent orders in place that were made in 2012 between both parents, which allowed for the child to spend time with both parents. The mother dies while the child was in the father's care, and the father chose not to return the child. At appeal, the grandmother was unsuccessful and orders made for the child to reside with the father and have regular contact with the maternal grandmother. Now, looking at the relevant provisions that was considered in this case, of course, that was 60CA, which is the child's best interest, the paramount consideration in making a parenting order. That's fairly standard. And also, under 60CC is how the court determines what is in the best interest of the child. And the case law that found that is Good and Good in 2006. So a quick look at Good and Good. This actually looks at how the child's best interests are determined. And it looks at identifying the competing proposals between the parties, identifying the issues in dispute in the interim hearing, identifying any agreed or uncontested relevant facts, considering the matters in 60CC that are relevant, and if possible, making findings upon them, and deciding whether the presumption of 61DA that equal shared parental responsibility is in the best interests of the child applies or does not apply. So, in conclusion, the best interests of the child are paramount. If uncontested or absence of unacceptable risk, then seeking orders that the child reside with the other parent is relatively straightforward. There is no requirement that parenting orders exist or the surviving parent does not have parental responsibility. Okay, hope this helps.